Afternoon, everybody. It's lovely to be here. Good to see some familiar names, if not faces, but some familiar names. So good to have you all here. As Heather was saying, Bronya and I are associates in the employment team. We do lots of work with social care clients, and much of that is advising on TUPE transactions. So we designed this afternoon's webinar to be a bit of a sort of introduction to TUPE for those of you who aren't so familiar with it. A reminder for those of you who are more familiar with it of some of the basics, and we've tailored it specifically for you as social care organisations to focus it on the things that we're asked most about when we're advising on transactions. I'm going to be talking about what TUPE is, the two types of transfer that invoke TUPE, what it means for employees and employers, which staff transfer, so how to determine who actually transfers, warranties and indemnities in contracts, and post-transfer harmonisation. And then Bronya is going to take you through the practical steps that are required of you in relation to a TUPE transfer. And as Heather said, we'll have time for questions at the end. We'll explain the terminology that you need as we go along, but we have put a glossary at the end of the slide deck, so you can go back and check your understanding of any of the terms that we're using. Okay, can I have the next slide, please, Bronya? So TUPE is a piece of legislation which governs what happens to staff when businesses or parts of businesses are bought or sold, or when services are transferred. The key to understanding TUPE is the word protection in the title. So transfer of undertakings, protection of employment. So it's the key word there. It's about protecting staff. Staff who transfer under TUPE from one employer to another are entitled to keep their old terms and conditions and have all their employment rights protected. It's almost as if the transfer hadn't happened. It's just the name of their employer that changes. It's a tricky bit of legislation, or it can be tricky, because there's so much of it that can be debated and argued over on any particular transaction. So we're often arguing over whether or not it even applies. Sometimes it's a bit of a grey area which staff it might apply to on a particular transaction. And it's also debatable sometimes what the effect of it actually is on those staff. And those are the three areas that I will be focusing on. In terms of terminology, TUPE legislation refers to the seller of a business or the old employer as the transferor, and the buyer of the business or the new employer as the transferee. But for clarity and to avoid confusion, I'm going to try to stick to saying old employer, new employer, or seller, buyer, so that we can keep that straight in our minds for today. Okay, next slide, please. So, as I said a few moments ago, there are two types of TUPE transfer, and this slide is about the first type of transfer, which is a business transfer. This is the original type of TUPE transfer. When TUPE was first invented, this was the only type of TUPE transfer. This is where an undertaking, which is the word that is used in the regulations to mean business, or part of an undertaking, is transferred from one employer, one organisation, to another. For TUPE to be invoked in this type of transfer, the business or the part of the business must be an economic entity by itself, and there must be an organised grouping of resources comprising that entity pursuing an economic activity. And the entity has to retain its identity after the transfer, the same as it was before. So in other words, there must be something identifiable or recognisable carrying out the same activity after the transfer. So an example of a business transfer would be if Jackie, an imaginary person Jackie, were to sell her care home to John. As long as John continued to run it as a care home, then that would probably invoke TUPE. It'd probably be a business transfer, and the staff would transfer to John. If Jackie ran the care home via a company called Jackie Care Limited, and she sold the shares in that company to John, then the staff would still be employed by the company and there wouldn't be a TUPE transfer. It would just have been the shares that were sold. So a share sale does not invoke a TUPE transfer. The third scenario, using my Jackie and John analogy, would be if Jackie sold all the business assets, including the building, the care home building, to John, and John converted it into something else, say a lovely big Airbnb property, something like that. TUPE wouldn't apply there, would not apply there, because the business wouldn't be the same afterwards. So there might still be some jobs to do. There might still be cleaning and maybe some catering, but it's a completely different type of entity, isn't it? Okay, next slide, please. We're going to look at the other type of TUPE transfer now. This is the type of TUPE transfer that only came later in the legislation, and it's the type of transfer where there's a service provision change. Okay, so where a contract or service is transferred from one organisation to another through, say, outsourcing or retendering or bringing in-house. These types of transfer follow a contract generally. So, for example, a contract with a local authority to take over someone's care. For there to be an SPC, it's what we sometimes call a service provision change, an SPC, the service must be provided by an organised grouping of employees, and that organised grouping has to have as its principal purpose the carrying out of activities on behalf of a client. And that client has to stay the same before and after the transfer. So a straightforward example of an SPC would be where it's slightly unusual, okay, just bear with me with this one. It would be where a care home decided to outsource its catering to a catering company, okay? So they've decided we're not going to do our own cooking and catering for our residents, we're going to outsource the catering, as lots of, for example, schools do, I know. So any kitchen staff employed by the care home would almost certainly transfer to the catering company, and that would be an SPC, a service provision change. It would be outsourcing, or first generation outsourcing, we sometimes call it as well. So the client stays the same. The client is going to be the care home before and after. For this to invoke TUPE, we would need to consider whether there is an organised grouping of employees carrying out the activities. Now, assuming there is a dedicated team of kitchen staff, which I think most care homes would have, that should be quite straightforward. Imagine, however, a care home where there weren't any dedicated kitchen staff. Imagine it's a care home where actually carers kind of bob in and out of the kitchen and make food as and when required. In which case, there probably wouldn't be an organised grouping of employees who do the catering. And then you probably wouldn't get a TUPE transfer of the catering staff if the catering was outsourced. And finally, we also always need to consider whether the activities are the same before and after the transfer. So we're still talking about the outsourcing of catering at this care home. And this is even more of a stretch for my analogy, but imagine a scenario where the catering company that you're outsourcing to decides that instead of actually catering on the premises, they're going to just deliver microwavable meals for residents to heat up for themselves. Now, that is a very different activity, isn't it, from actually cooking and serving food on the premises. So probably TUPE wouldn't apply there because the activity is fundamentally different after the transfer. Imagine you've outsourced something like the catering. If that company subcontracts again to a different company, then that's what we would sometimes call second generation outsourcing. So there'd be another TUPE transfer potentially to that next generation of outsourcing. So imagine we've done this. We've done the outsourcing. We've contracted with a outside contractor to do the catering. But we, for whatever reason, we decide that that's not working for us, or we want to go down a different route. Maybe it was too expensive. Maybe we weren't happy with how the contractors were running it, and we decide to bring it back in-house. We're going to do the catering back in-house, so we're going to employ the caterers ourselves. That's what we call in-housing, and that is a service provision change, probably again bringing the staff back to be employed by the care home directly. So a TUPE transfer in the opposite direction. A more common example of an SPC would be where a domiciliary care company loses a contract with a local authority to provide a particular care package, and the package is recommissioned to be provided by a competitor. So one company loses it, another different company gains the contract, resulting in a staff TUPE transfer from the original provider to the new provider. So there's no contractual relationship between the old and the new provider. That's worth bearing in mind, and we'll come back to that when we're talking about warranties and indemnities, only between the provider, each provider, and the local authority. Okay, so we've looked at the two types of transfer. Now on the next slide, please, we're going to start looking at who actually transfers. Right. I always say to clients that as much as we talk about the staff and who might transfer, who will and who won't transfer, and what the various interested parties want to happen, ultimately it's not open to it's not an agreement of the parties which decides who transfers or who doesn't transfer. Obviously there needs to be discussion, conversation, and an element of agreement, but ultimately if there's any dispute about who did or didn't transfer, it's the courts, or in this case the employment tribunal, who will decide whether someone will transfer, won't transfer, did transfer, didn't transfer in the past. From a practical perspective, what usually happens is that the seller, the old employer, sort of lists the staff whom it believes are in scope to transfer. So this is slightly encroaching on what Bronya is going to talk about. But so initially the seller presents a list of people they think will transfer, and the buyer looks at it and potentially challenges it, but ultimately will decide whether they still want to go ahead with the transfer and take on the service or buy the business with those employees in scope to transfer. Are those staff, though, assigned to the organised grouping? That's what we need to decide to know whether they actually really will transfer. And it's sometimes difficult to establish whether they are assigned to that organised grouping. This is especially the case where staff might work across multiple services. So you might just have one service in scope to transfer, but you've got staff working across multiple services, so they only spend some of their time working in that transferring service. These can be quite tricky. There are a number of factors that you need to look at to help answer this question. The main one is time spent, and it's a rule of thumb which I'm afraid is so well used that it's overused. It's not a bad starting point, but don't get hung up on it, okay? The rule of thumb is that if someone spends more than 50% of their working time working in the transferring service, then they're probably assigned to it. But be really careful using that rule of thumb, okay? The problem with over-relying on it is that you tend to forget about some other important factors, things like seniority and the reality of the roles that people are doing in the transferring service. So I'll give you an example, which is at the sort of easy end of the spectrum, and obviously there's cases that fall in between, but imagine a manager, imagine a person, an employee who is a manager in the transferring service. So she's quite senior. She spends 45% of her working time in the transferring service, and the rest of her time, the other 55% of her time, she's bobbing in and out of other, say, 5 or 10 other services, assisting with less important or less senior sort of roles and admin tasks. So even though she's working for less than half of her time in the transferring service, I hope that you can see that as a manager, someone quite senior in the transferring service, she probably is actually assigned to it, even though she's there for less than half of her time. There's a little note on that slide about not forgetting about people who are absent. So being off sick or on maternity leave or disciplinary suspension doesn't mean that an employee isn't assigned. So don't forget about those staff. Now, if you're the seller, if you're the old employer, there is nothing explicit in TUPE that says that you can't reconfigure your staffing somewhat before a transfer happens. You might do that to make it clearer who will transfer. So where you have people working across a number of services, you might slightly jiggle things around to make it clearer who's going to be in scope to transfer, who is assigned to the transferring service. But just be careful about this. Completely restructuring your staffing model to deliberately circumvent or sort of manipulate the effects of TUPE can be quite problematic. It might be subject to challenge. Companies have been tempted in the past, I have seen this, to move undesirable staff deliberately into scope for transfer just to get rid of them, or just to achieve a particular outcome. It's not always as Machiavellian as that. But that can be subject to challenge both by the employees themselves or the receiving employer, and even by a commissioner if it's a service that you're providing to a commissioner. So yeah, just be mindful of that. But there obviously are degrees of that. So sometimes it is just a case of trying to make things clearer ahead of the transfer. If you are going to be looking to do something like that, you need to be looking well in advance of the transfer and possibly taking advice on it before you do, legal advice on it. Okay, so we've looked at what TUPE is and who transfers. Next, we're going to look at the effect of the transfer on the next slide, please. So employees assigned to the transferring service are entitled to keep their old terms and conditions and all their employment rights as if the transfer hadn't happened. The analogy I use, which conveniently can be associated with a pretty picture for this slide, is transferring a nest very carefully, a bird's nest, carefully from one tree to another. And the eggs in the nest represent each of the individual employment rights. So you'd have a lot more eggs in the nest than this. TUPE automatically moves the nest from one tree or employer to another. And the idea is that it should all stay intact. The new employer has to preserve all the rights. Don't let any of the eggs fall and break. Don't forget to bring any of them across and don't drop them. Bronya is going to talk to you about the fact that employees can object to the move. I suppose the employee might be the bird. I'm not quite sure if the analogy doesn't really stretch very well to the who the employee is. And Bronya is going to talk about what happens if the employee doesn't want to move to a new tree. But they do. If they do object to the transfer, they have no rights to stay with the old employer necessarily. Okay, we're going to look at this in a bit more detail now on the next slide. What it means for staff in practice. To begin with, before the transfer even happens, affected staff, and that could mean staff who were transferring, but also wider than that, even staff who are affected by the transfer, even when they don't transfer, have a right to be provided with certain information, which Bronya will talk to you about. As we saw on the last slide, terms and conditions move with them, including salary, benefits, their continuity of service is preserved. So when you inherit an employee under TUPE who's been in post for 20 years, they still have 20 years service after the transfer. They don't start from scratch with their continuity of service. In fact, all employment liabilities in respect of the transferring staff are assumed by the new employer. The new employer becomes legally responsible for everything the old employer did or failed to do before the transfer, any underpayment of wages, contractual breaches, discrimination. So taking over a contract where you suspect the previous employer might not have conducted themselves very well, might have done things wrong, is a red flag. And we'll come back to what you can do about that. I said a few seconds ago that all terms and conditions are protected. The exception to this is in relation to pensions. It can get a bit complicated, but essentially the right to an occupational pension scheme does not transfer. Instead, there's an obligation to provide a broadly comparable scheme. But essentially, the special rules around pensions are just a bit too detailed for us to go into today. In reality, often if it's the previous employer provided access to a stakeholder pension, you'll do the same thing, which you'd have to do anyway. Now, it's not just the contracts themselves that transfer, it's the rights connected to an employment contract, and that can actually catches people out sometimes, but it can include rights that arise under policies rather than in the contract itself. And the most common examples of this are policies around payments. So if someone has a either express or implied right to something like pay protection under a pay protection policy, certain maternity or paternity pay rights, they will often transfer as well. So when you do your due diligence, you need to be looking a bit further than just the contracts themselves, and you'd usually ask for the policies as well. So employees are protected from detriment once they've transferred. Now that means being subjected to a disadvantage, and they're protected from being dismissed as well because of the transfer for a reason connected to the transfer. It's automatically unfair to dismiss an employee where the sole or principal reason for the dismissal was the transfer. Currently, staff have to have more than 2 years service to bring this type of unfair dismissal claim. But as you might have heard, the government's going to be abolishing the 2-year qualifying period for unfair dismissal. And as far as we know, that will apply in TUPE as well. To be clear, just because staff have been TUPE'd doesn't make them bulletproof. You can still sack someone after they've been TUPE transferred. Similar to how we say somebody who's a whistleblower is not bulletproof. You can still dismiss them for a reason unconnected to the whistleblowing, and in this case, unconnected to the TUPE. It's common to need to restructure after a TUPE, but you just must remember that the new staff mustn't be treated less favourably than your existing staff in terms of identifying them for redundancy. So you generally would be looking to pool everybody, or at least you wouldn't just be pooling the new TUPE staff ahead of other staff. So I've been talking about your potential liabilities, and next I'm going to talk to you about how you might limit your liabilities on the next slide, please. So first and foremost, I'd say that to limit your exposure under TUPE, the most important thing to do is to understand, to get clued up on what you're inheriting, who you're inheriting, in terms of the individuals. Bronya is going to cover that. The second thing you need to do is make sure that the business you're buying or the contract that you're taking on is appropriately priced to reflect the risk. And third, you can try to agree to share employment risk sometimes between the buyer and the seller, or the old employer and the new employer, in contractual terms. Now, you won't always get an opportunity to do this, so bear with me while I explain. The most common scenario for doing this would be under a service level agreement. So if you're taking on a contract where you've got an SLA in place, the service provider can agree terms under which they'll perform the service. And although the contract can't override TUPE, You can negotiate warranties and indemnities, which can be sort of protective for you, can mitigate the effects of TUPE. Warranties and indemnities are clauses that you add that allocate risk between the two parties. You can't have warranties and indemnities between the old provider and the new provider where you've got a commissioner in between you. Okay, so if you're taking over a contract that's being commissioned to you, then your only warranties and indemnities are with the commissioner, and that's where you might struggle to put them in place because lots of depends who has leverage, who has the power in the negotiations. Often there's no possibility for warranties and indemnities with public authorities, for example. And price is an important factor. The contract might already be priced in such a way that you're considered to be compensated for your employment risks, but understanding what those risks are absolutely key. So a warranty is a kind of guarantee. It's a contractual statement that something is true. So ideally, you would have a warranty from whoever you're inheriting the staff from, saying that the staff, well, you could say all sorts, but a helpful thing for it to say is that the staff list is correct and that the staff that they've listed as in scope to transfer are indeed subject to TUPE, and they're the only ones who will transfer. You could also have a warranty to say that staff have been paid properly up until the date of transfer. Okay, so that's great. If you can to have as many of these promises as possible, these warranties, it means that you can sue the other party, put in a claim against them if that turns out to be incorrect. Indemnities are a step better than a warranty. They're a contractual promise to compensate the other party for specific losses or liabilities. So a common indemnity in a TUPE transaction would be for the parties to agree that they will each remain responsible for employment liabilities that related to the period where they employed the staff. So although liabilities transfer from seller to buyer under TUPE, this kind of agrees that actually behind the scenes we'll each pay our way. The seller would say, for example, that anything that happens to staff before the transfer, I'll pay for if it goes wrong, and the buyer says, yep, and I'll just pay anything that goes on afterwards. I'll be responsible for that, and they agree to reimburse each other if either of them are at fault. As I said, it's not always possible to do this. These warranties and indemnities need to be professionally drafted by solicitors, so you will need to take legal advice on those. Okay, next slide, please. Just before I hand over to Bronya, something that an employer might want to do after the transfer, which I wanted to mention to you, is a popular approach. They often try to or want to harmonise terms and conditions of employment. So when you take on a new staff group, ideally you wouldn't have lots of different staff groups on different terms and conditions because you've inherited them from lots of different employers. Ideally, you would harmonise them all to be on your own terms and conditions. This can be difficult to achieve, and that's why I wanted to refer to it, because TUPE specifically prohibits changing terms and conditions for the purpose of harmonisation, because the very point of the regulations is to protect an employee's position and their terms and conditions. If you, if an old employer or a new employer actually makes a substantial change to someone's working conditions and that change is in connection with a TUPE transfer, the change will be unlawful and it will be void, so invalid, unless the reason for that change is an economic, technical, or organisational reason that entails changes in the workforce, so what we call an ETO reason. In that case, it's permissible. Entailing changes in the workforce, though, basically means changes in relation to the number or function of your workforce. So there would need to be a substantial reorganisation of people's duties or a reduction in headcount. So essentially, where you're going through organisational change, you're making redundancies, that would mean that you'd be able to look to an ETO reason to be making changes to terms and conditions. If you do not have an ETO reason, then there are some ways that you can avoid or reduce the risk of harmonisation being void and unlawful. First of all, how much time has passed since the transfer? So the more time that passes, the less likely the changes that you're wanting to make will be seen as being linked to the transfer. But it's a big but. There is no safe period of time. Even 2-3 years after the transfer, the changes that you're making, if you're harmonising, can still be linked back to the transfer, then they'll still be invalid and void. Second, you can try to offer incentives to encourage staff to agree to the changes. So if you're improving their terms and conditions overall to match your existing staff, kind of levelling up, this is generally permissible because they're agreeing and it's a net benefit to them. Third, you could look at red circling, so protecting higher rates of pay for transferred employees and then gradually increasing other rates of pay to the same level. And then finally, phased implementation is generally less risky because you're changing gradually and minimising disruption, allowing people time to adjust. Given the complexity of TUPE and the risks involved changing terms and conditions, we always suggest taking legal advice before you go ahead and change terms and conditions. And we'd say do this well in advance. So not just at the time when you wanted to make the change, but ideally before the transfer even happens, so that you're not going ahead with the TUPE transfer with any incorrect assumptions about what you're going to be doing afterwards. Okay, thank you. I'm handing over to Bronya now, who's going to step in and talk you through some of the practical things that you need to be doing surrounding a TUPE transfer. Thank you, Bronya.
Thank you, Julia, and good afternoon, everyone. So Julia has taken you through what TUPE means for all the parties involved, but I'm going to be looking at kind of the practicalities of it all. So bear with me slightly because they're not particularly thrilling, I'm afraid. So how do we actually carry out this TUPE process? Well, one of the key stages in the TUPE process is the sharing of the employee liability information, so what we call ELI, and that sharing happens between the seller to the buyer. Now, the seller will collate the key information about the staff that are believed to automatically transfer in the TUPE process, and that information must be provided to the buyer at least 28 days before the transfer date. But in practice, it's often shared a lot earlier to allow the buyer to understand exactly what they're taking on. Alternatively, and this can only take place in sort of real exceptional circumstances, but if there's a reason that it's not been reasonably practicable to meet that 28-day deadline, then the ELI must be provided as soon as reasonably practicable. We do find that sometimes anonymised or reduced information may even be shared at a much more formative stage of the process, and that's just so a prospective buyer can considering whether they want to enter into the transaction at all, and if so they can look at things like pricing and negotiation. The TUPE regulations set out very clearly exactly what information needs to be shared by the seller. So that includes names and ages of transferring employees, all the Section 1 Employment Rights Act particulars, so that's all the key information that must legally be in someone's contract of employment, any information regarding disciplinaries, grievances or claims in the last 2 years or potential claims, any collective agreements that apply, and also information around the use of agency workers. And when we're looking at that last point, the use of agency workers, the seller must share specific information about their use of agency workers across the entirety of the business. So it's not just the area that might be being sold or subject to the transfer. Now, whilst those regulations are very specific about the information that must be shared, what they're not so specific about is the format that it's provided in. So provided it's in writing or otherwise readily accessible, that's okay. Usually we see this sort of information being presented in kind of table format. That's just a sort of an easy way to collate it and share it. But as I said, as long as it's sort of readily accessible, that's fine. And we actually have a template that we use or share with our clients to use, which I'll show you in a moment so you can see what that looks like. As Julia has mentioned earlier, it's important that the seller does not forget about people that are away from work when they're collating this information. So if someone's off on family-friendly leave, sick leave, or anything like that, if they need to be captured, their information must be included at this stage as well. And it's also important to include anyone that might have transferred if they hadn't already utilised their right to opt out of the transfer. So just to touch on opting out, because I know Julia mentioned it earlier, any employee who is due to transfer can choose to opt out of the transfer process. But what that means is that their contract of employment will automatically terminate. So it doesn't just mean they get to stay with the seller, it means that their employment ends. Now, it's then up to them and the seller if they want to reach an agreement about a new contract, or it might be that they go and look for work elsewhere. But it's important to understand that that's the effect of it. And if someone only opts out because there are sort of substantial changes made to their terms or conditions, or there are proposed changes, then that could actually be treated as if they've been dismissed, and there might actually be an ability to bring a claim there. So just something to be mindful of. It was previously accepted that TUPE did not apply to workers, only employees. That's kind of the general principle that we're all working to. However, there has been a first instance tribunal decision back in 2018 that muddied the water slightly. And in that case, a worker was actually found to satisfy the definition of employee in those particular circumstances. The position is therefore slightly unclear at the moment, and the Conservative government had launched a consultation on whether to amend the wording in TUPE just to make that position much clearer, that it did not apply to workers. We're not sure whether that's going to be picked up by the Labour government. So if you're ever unsure around that, again, probably a time to seek some advice and guidance. And then once the ELI information has been provided, the seller must provide written notification of any changes. So there's kind of a general ongoing obligation to make sure that that information is up to date. As I said, we have a kind of template document for setting out ELI that we share with clients sometimes just to make that process a little bit easier. Just a snapshot of it there on the slide for you to see. As I said before, that information doesn't have to be in a specific format, but we usually find a table like this kind of the most helpful way to lay it out. Our template does actually have a lot more columns. I've just shown you a little sort of screen print of that there, just so that you can actually see what it looks like, and it's not too small on the slide there. So what does the buyer need to do at this stage? Well, the buyer will want to carry out what we call due diligence to ascertain whether they want to take on the business or the part of the business, and to understand what the risks and the obligations are associated with doing that. So that's going to include finding out as much as possible about the business and the proposed transaction. And part of that is reviewing the ELI that they are sent by the seller to understand any potential employment liabilities. That might, as I said earlier, impact on things like negotiations and pricing, or it might just be so that they've got that information, they can understand what their obligations are going to be in due course, who they're going to be taking on, what terms they're taking them on. Some organisations will do their own due diligence process, but we're also often instructed to help clients with that process, and we can prepare what we call due diligence reports, which can be helpful in kind of reviewing that information and highlighting any risks that we see there. There are some kind of key things or red flags that you want to be looking out for when you're reviewing the ELI. So you're going to want to understand the salary and benefits that you're going to be liable for in due course. You're going to be looking at whether employees' terms and conditions are in line with the minimum statutory requirements. So you don't want to be taking on any liabilities for failure for those being met in the past. Looking at things like whether staff have been receiving at least the national minimum wage. You also might be looking out for any signs that there might be some discrimination or equal pay issues in the way they're treating their various employees. Are there any disputes that you might be taking on the liability for? And if there are a high number of past disputes, does that indicate any issues perhaps with the culture of the business? You'll also be looking at employees' length of service, because that can be an indication of future likely costs or risks. So employees with over 2 years service have additional rights, one of them being the right to bring an unfair dismissal claim, albeit, as Julia mentioned, Labour does intend to remove that service requirement. But long service can also mean high redundancy payments. So if you're thinking about having to restructure at some point in the future, that might also be something you need to be factoring in. Remember that in some sectors, reckonable service is also really important. So not just someone's legal continuous service, but any reckonable service with similar employers in the past. That might be important for calculating things like redundancy pay. And it's not something that is required to be part of the ALI. So it might be something you want to look out for, check if it's there, ask for perhaps if it's not included. And high absence levels, so things like sickness absence. Again, that could indicate that there's maybe an underlying problem with the business. If there's lots of people off well or absent, there's also a cost involved in that, obviously. And again, you might want to just be live to any potential sort of disability discrimination issues or anything like that. It's important to remember, as Julia said, that TUPE operates automatically. So even if an employee is mistakenly left off the ELI or purposefully left off the ELI, if they're caught by TUPE, they will automatically transfer anyway. So what can you do about that if you unexpectedly receive someone that you weren't expecting to? Well, a buyer can make a complaint to the Employment Tribunal in relation to the seller's failure to provide the necessary ELI, and that is a claim that must be brought within 3 months of the date of transfer. If they're successful, the ET can order the seller to pay the buyer compensation, and it looks at what is just and equitable in the circumstances. So it will look at whether there are any contractually agreed terms between the parties. So things like if there are any warranties or indemnities that exist. But it will also look at any losses that the buyer has suffered. And there is a minimum of £500 compensation per employee in respect of which information has not been provided. So as you can imagine, if we're talking about large numbers of employees transferring in some transactions, that can add up quite quickly. And as I did say, things like indemnities, warranties, they provide that added layer of protection there if there are any kind of unexpected liabilities. Aside from providing the ELI, the seller and the buyer have a duty to inform and potentially in some cases to also consult. And I'm going to go into exactly what that means over the next few slides. But I should start by saying that this is a duty that applies in respect of what we call the affected employees. So who are the affected employees? Well, they're not just the employees that are going to transfer. Those are the obvious ones, but it could be wider than that. So they're also employees whose jobs may be affected in one way or another by the transfer. Just to give you an example, so when we're looking at the transfer of part of a business, this might be a sort of more pertinent factor. There may be staff that are going to remain with the seller, so they're not part of the service that's transferring, but their jobs are nevertheless impacted by the fact that there is this transfer happening. Equally, there might be staff already employed by the buyer whose jobs may also be impacted by the fact that some people are transferring in. And TUPE only requires a buyer or a seller to inform or consult in respect of their own employees. So what that means is there is no obligation on the buyer to directly inform or consult with the seller's staff pre-transfer, even if those staff are coming over to them at some point at a later date. So who are we informing or consulting with? So an employer has a duty to inform and possibly consult with what we call the appropriate representatives, rather than directly with employees. So it's really important to get this right. So you're not sending the information or consulting with the wrong people. It's got to be the appropriate representatives. And what that means is employers have to appoint employee representatives to deal with this TUPE process. And there are some additional rights and protections that come with being an appropriate representative. So representatives are protected from detriment or dismissal related to their role. There are a couple of exceptions to this, as there always are. The first being where the affected employees are already represented by an independent trade union, which is recognised for collective bargaining. So in those circumstances, you basically already have your appropriate representatives. They are the trade union reps, so there's no need to do an election process in addition. There will be occasions where you might have a trade union, but it's only recognised for some of your staff. And then you may need to think about liaising with them, but also potentially having some kind of election in relation to the other staff to make sure that everyone is properly represented. You may also have some existing employee representatives in place, and that might mean that you don't have to run a specific election process for your TUPE process. An example of that might be if you have some kind of employee forum. Key thing to think about there is what the role is of those representatives. So do they have sufficient authority to deal with TUPE matters, or was their role something completely different? If they don't have sufficient authority, then of course you're going to need to elect and go through that process. The final exception is where an employer can, in fact, inform and consult directly with their affected employees. They don't have to have any representatives whatsoever. And this is what we call the micro businesses exemption. And that's where an employer has fewer than 50 employees in total, or if there are fewer than 10 employees that are going to be involved in the transfer. So that's the only time you can speak directly to the employees as part of this process. There are detailed regulations around the election of employee representatives and their responsibilities. So I'm not going to go sort of through them in too much detail, but I'll run through them in a summary for you, the kind of key points. The first point, which hopefully kind of goes without saying, is that you need, as far as possible, to ensure that you're following a fair election process. All the candidates in that election must be affected employees themselves, and no affected employee should be unreasonably excluded. So they should all have the right to vote and be part of that process. It is actually up to the employer to determine how many representatives are going to be appointed, but there does need to be sufficient representatives to make sure that you're representing the interests of all the affected employees. So one of the things you might want to consider is whether the same group of representatives are going to represent all of the affected employees, or whether you might have different groups or classes of employees that might be better represented by having their own separate reps. So just something to think about. You'll also need to be thinking about their term of office. So are they just going to be appointed for the TUPE process itself, or is this part of a wider election process? But at an absolute minimum, of course, they need to be in place for the whole of the information and the consultation process so that they can sort of oversee that. As far as reasonably practicable, the voting should be held in secret. And again, hopefully goes without saying that you need to be adding up those votes accurately. So what about the timing of all of this? Well, all we know is that this needs to take place in good time. So quite vague, but what we mean really by that is that the representatives need to be there, ready to go prior to the information and consultation process, so they have a real chance to oversee that process properly. If you invite the affected employees to elect representatives and they fail to do so in a reasonable time, then an employer can give all the necessary information directly to their employees. But what's key there is that you have given them that opportunity to elect their representatives. And then finally, just depending on the information that you're looking to share with those representatives, there may be cases where you think it's appropriate or necessary to enter into some kind of confidentiality agreement with the representatives. And that is something that you can look to do. Again, probably something to seek advice on, but that is a possibility if that's a concern for you. So looking at the duty to inform, to start with. So this is a duty to provide specific information to the appropriate representatives, or where the exception applies to the employees directly. And that includes some very specific things that you've got to tell them about. So the first is just the fact that the transfer is going to be taking place at all. The date or the proposed date for when it's going to be taking place, and all your reasons for why that is happening. You also need to include any legal, economic and social implications for the transfer. What do we mean by that? Well, essentially we mean that the representatives have to have sufficient information about the buyer to really assess the impact that this transfer is going to have. Just to give you a few examples of that then. So legal implications, that might be the fact that TUPE is going to apply in the first instance and what that means. And it might also be any sort of proposed changes to terms and conditions, things like that. We then have the economic implications. So that might be things like potential effect on pay or the amount of work available. And then social implications, which might be things like changes in working shifts or plans to move the location of the business. There's also a duty to include information about any measures that an employer envisages taking in connection with the transfer. And the seller must also set out any information about the measures it understands the buyer envisages taking in relation to the transferring employees. And if there aren't any measures envisaged, then that needs to be specifically stated. So you don't just leave it off your letter. You have to specifically make that clear. And I'm going to be looking at precisely what I mean by measures in a moment. So we will come back to that. Again, there's also a requirement to provide certain information around the use of agency workers. And again, that's the use of agency workers across the business and not just to the area that's transferring. There are specific rules about how and where this information needs to be sent. I'm not going to go into detail on that, mostly because it depends on who your appropriate representatives are. So there's obviously lots of connotations there. But just something for you to be aware of. And we are often instructed by clients to put together suites of template letters, making sure that this is all carried out correctly. So making sure you've got the right information going to the right place at the right time. As you might expect, it's quite easy to make a kind of technical error here. It's all kind of process driven, but if you leave one thing off the list, you could be in some difficulty. So just important to get that right and tick all the boxes. In some cases, but not all cases, there's also going to be a duty to consult. Now, in a lot of TUPE processes, even when that legal obligation to consult hasn't arisen, parties may decide to consult with the appropriate representatives anyway, just to make sure that everyone knows what's happening, everyone feels comfortable, there's kind of a smooth transfer. But there's only certain cases where the legal duty actually bites. And that arises when an employer envisages taking measures in relation to any affected employees in connection with the transfer. So I've mentioned measures a few times and I said I'd come back to it. So what are these? Well, the definition is that they are any action or arrangement in connection with the transfer which affects the employee's working conditions. Quite a wide definition, but it can be anything really, like a change of base, a reorganisation process, a change in the pay date, anything like that. And this only bites when these changes are actually envisaged. So when there's some kind of definite plan or proposal that you've got in place to make these changes or to take these actions, rather than just kind of a mere possibility that something one day might change. So it's really when you've got these things in mind. The courts have previously said that there is a distinction between measures that are taken as a result of the transfer and just inevitable administrative consequences, and the latter you don't need to consult on. In reality, that is a really hard distinction to draw, and there's not much guidance on it. So if in doubt, better to go through the consultation process rather than find out that you should have consulted and you haven't and you're in breach of the regulations. You should always be consulting with a view to seeking agreement. Now, that's not always going to be possible. You're not always going to get there, but that should be the kind of underlying aim. It shouldn't be prejudged or a kind of sham process. That should be your genuine intention. And the duty to consult is only with your own employees. So that means that the seller does not need to consult about proposed changes by the buyer. It only needs to inform about those. Equally, the buyer does not need to consult with the seller's employees, even if they're going to be transferring over at some point. Also useful to be aware that where the buyer is proposing large-scale redundancies following the transfer, you might be aware that there is a duty to collectively consult in relation to redundancy process. There are actually legal provisions now in place that allow that collective redundancy consultation process to start pre-transfer, just to in effect speed up the whole process, if the parties are in agreement for it. Now, that's outside the scope of today's session, but it's just something to be aware of, just so that you know it exists. And if you think it's something that might apply to a process that you're involved in, then obviously that might be something to look into or seek advice on. So what about the timing of all of this? When do you need to inform and consult? The employer must inform the appropriate representatives with long enough before the relevant transfer to enable the employer of affected employees to consult with the appropriate representatives. So all very vague, but essentially what this means is it all needs to happen in good time. So you need to have a reasonable time period to properly go through this process. And if you do need to consult meaningfully. What is a reasonable time period is probably going to be somewhat dependent on the extent of any changes that you're proposing, because obviously that's going to require some more consultation. In any event, you need to make sure that the information and consultation process has taken place and concluded before the transfer. And as I said, any consultation should be actually meaningful. So that means there should be a genuine attempt to reach agreement. It shouldn't be a sham or misleading process. And again, just a reminder that you need to be including all affected employees, making sure you're not excluding someone just because they're away from work and you've forgotten about them. Make sure you're capturing everyone you need to include in that process. What happens if you do fail to inform or consult in line with the regulations or fall down in some way? Well, a claim could be brought against either of the employers in the employment tribunal, so either the seller or the buyer. Again, there's a 3-month time period for bringing a claim. Affected employees can bring a claim if there's a failure to elect employee reps properly. Employee reps can also bring claims in relation to any other failure relating to their role. Trade unions can bring claims in relation to a failure in respect of any of their trade union reps and their role in the process. And affected employees can also bring any other kind of claim around a failure to inform or consult properly with them. And if those are successful, both the buyer and the seller can be ordered to pay compensation in relation to the breaches carried out by them. And it's also open to the tribunal to make both the buyer and seller jointly and severably liable. And what that means is the employee or the rep could pursue either for that compensation. When we're looking at compensation, what kind of levels are we looking at? Well, a tribunal can order compensation as it considers to be just and equitable, but there is a limit of 13 weeks gross pay for each affected employee. So whilst it is limited, again, as you can imagine, particularly if we're talking about a large number of employees involved in the process, those numbers are going to quite quickly stack up. Just a couple of reminders for a buyer, and then I will draw to a close. It is possible for both the seller and the buyer to need to take measures in relation to employees, but more often than not, it's the buyer. Both should be considering it, but more often it is the buyer. Important to think carefully about whether there are proposed measures for transferring staff that need to be communicated to the seller so that they can inform properly and comply with their duties. Also need to think about any measures that you might be taking in relation to your existing staff that therefore require some consultation. Buyer will also need to consider pension arrangements for transferring staff. So pensions is a complex area. They're actually excluded from the kind of automatic transfer principle, but there are still sort of regulations around pensions. Not something that we can go into today just because of the complexity of pensions, but it is something to get advice on if you're unsure whatsoever. As I said, TUPE is quite a process-driven sort of set of regulations. So it's making sure you follow the steps and requirements very carefully. What that does mean is it's also quite easy to just fall down, just to miss one thing off the list or do things slightly out of order. And as I said earlier, clients will often get us on board to assist with the process, to do things like put together suites of template documents, just to make sure that that's all covered off, as well as the more kind of holistic advice on whether TUPE applies and things like that. Today has been a bit of a high-level whistle-stop tour of TUPE. There's a lot to consider, but hopefully it's given you a kind of idea of the main things that you need to be looking out for, red flags, and also just sort of flagging where you might be thinking, actually, maybe this is the point that I need to just get a little bit of extra support or advice here. Hopefully, if some of you have some time, and we can take a few questions now. And I'm also just going to turn to the glossary that Julia mentioned earlier that's got some of our kind of key terms for you to refer back to. Thanks.
Sue, would you like to come off mute to ask your question, please?
Yeah, hello everyone. Probably not a straightforward answer, but if somebody who's TUPE'd over, so they're already with us, the transfer's gone well, around changing their terms and conditions, if they request to change their hours. So what we would normally do is if they request to increase their hours and they're on quite favourable terms and conditions, we would want them to come off their TUPE terms. But I don't know if we're allowed to do that. But equally, what if they want to reduce their hours? Can we apply the same approach?
Well, it's effectively a negotiation. So you could say, in the same way that you could say no to them increasing or reducing their hours, you can also say, yes, but here is the new contracts that we're going to be offering you. It does get a bit complicated. I can think of a client who recently told me that I don't think they're here this afternoon, but they recently told me, I don't know whether you do this, that where somebody asks to increase their hours, you increase their hours and you put them on a contract only for those additional hours on your new style contract, and they stay, so they have two contracts at any one time. That seemed to be, I've actually got an outstanding query about that, which I need to get back to them on, but I hadn't come across that before and it sounded quite complicated to me. So I wouldn't recommend that at the moment. But yes, that can be where they're happy to do that and you're offering the increased hours on your style contract, then yeah, that can be a way for them to move across onto your type of contract.
But possibly not one that we can enforce?
No.
Okay, thank you. That answers that for me.
Okay.
Thank you, guys.
Obviously, please do take advantage of our social care advice line if you think of any questions afterwards. Julia and Bronya's details are on the slides as well. So do take advantage of contacting them with any questions if you have any afterwards. Thank you all very much indeed.